Hi, today Nick and I are going to take a look at intestacy, and we'll be answering questions such as what is it, why we need to know about it, and why it matters whether or not your clients have a will.
Hi Helen, thanks for asking me along today. So what actually is intestacy?
So Nick, this is the term used for individuals who die without making a will. Legislation is in place that deals with how a person's estate is distributed when they die. So when there is no will in place, there are different rules for England and Wales, Scotland and Northern Ireland.
So why do we need to know about intestacy?
Well, Nick, everyone should have a will so that they can make sure their assets end up with their intended beneficiaries. So partners need to know what the consequences are for those clients who do not have a will on the distribution of their estate on death. Did you know, Nick, that currently only 43% of adults have a will? This means that over 31 million people do not have a will and risk having their hard-earned cash and assets being left to individuals that they may have not chosen. They also risk inheritance tax being paid on their death, as they cannot control who ultimately gets their estate.
So dying without a will means that their estate will be left in a manner prescribed by law and may not be distributed as they would have intended.
Yes, so for example, in England and Wales, if you die leaving a wife and children, the law states that your wife gets all of your personal possessions. So she'll get the jewellery, ornaments, your car, for example, and the technical name for these are chattels. The wife also gets £270,000 and half of the balance of the rest of the estate. So the rest of the estate is called the residue, and the children will get the other half of the balance of the estate.
And the rules are different in Scotland.
Yes, Nick, it's kind of quirky when it comes to intestacy in Scotland, because there are two distinct sets of rights for the spouse and the children. The spouse has what we call prior rights, and that will give her an entitlement to the house up to the value of £473,000. Then she gets furniture up to the value of £29,000, and she gets £50,000 in cash if there are children of the marriage. If there are no children, she gets £89,000. The prior rights are settled first after any debts and inheritance tax, and then legal rights are settled.
Legal rights. Have you any more information on that?
So, Nick, legal rights apply to what is known as the movable estate in Scotland, which is just all of the other assets apart from land or buildings. So it's your investments and your cash. So if you're married and there are children, the spouse gets a third of the movable estate and the children also get a third. The balance after this is distributed to children, grandchildren or great-grandchildren. And if there are none, it will pass to other members of the family.
And finally, what are the rules in Northern Ireland?
So in Northern Ireland, if the estate is below £250,000, everything goes to the spouse. However, if it's over £250,000, the spouse gets all of the personal items and £250,000 if there are children. And if there are no children of the marriage, this increases to £450,000. And if there's one child, they get 50% of everything after the spouse gets her entitlement, or a third if there is more than one child.
What happens if there's no family members?
So under intestacy, if there are no surviving family members, the estate goes to the Crown, and that is called bona vacante.
Okay, and what about the process? Who deals with an estate if there's no will?
So it's a similar process in that an individual has to apply for probate, which is just the legal right to deal with the property and affairs of the deceased individual. Normally, the closest living relative will apply to become what is called the administrator of the estate, and a document will be issued called the Letters of Administration, which will allow the estate to be dealt with and distributed.
Okay, and what about inheritance tax and intestacy?
So Nick, the inheritance tax rules still apply to intestacy. So any assets left to your spouse or civil partner will qualify for interspouse exemption. However, assets left to children or other family members will use up any available nil rate bands or residence nil rate band and may be subject to inheritance tax, which of course has got to be paid before any distributions of the estate are made. Interestingly though, if there are no surviving relatives and the estate is left to the Crown, it's immune from inheritance tax. So as you can see, Nick, it can get very complex, and it's really important that our clients make wills to ensure that they've got control on how their assets are distributed on their death. It's also worth noting for clients who die domiciled in Scotland, they cannot what we call disinherit their children. So legal rights not only apply on intestacy, but they also apply where there is a will. So it may be that these clients ought to consider setting up trusts to ensure that their assets are left in accordance with their wishes. Remember, legal rights do not apply to land or property, but they do apply to investments and cash. So it's really important for clients in Scotland who do not want to leave an inheritance to any of their children, perhaps because they are estranged or just that they're bad apples, that they make sure that they either use a trust or do some will planning to make sure the right people get the right assets. And as you can see, this is just a summary of the rules. And if you want some further details, you can find information on our TechLink pages. We've got lots of detailed information on the intestacy rules in England and Wales, Northern Ireland and Scotland.